Just give us a brief transition moment here.
Yeah, it may take a moment for us to figure out how
We're having tech problems.
yeah, how to have our guests permanently displayed on the screen. Okay, who's Justice? Can ask to unmute.
I'll ask her to turn her camera.
And
I'm here, Jocelyn.
hello, Justice Greenwood.
Just to reassure you.
you are here. Oh, good. All right.
Need to unmute her again.
Okay.
That's fine.
Yeah.
Oh, okay.
Yeah,
Yes, approve. Great.
Anna and turn her
Wait,
camera.
there. Okay. Ask to unmute. I think that I can turn the camera on.
Let me ask her.
Okay. Let me see if I can find. There you are, M. Greenwood. Okay, I'm gonna pin you so that people can see your smiling face. Thank you.
Hello.
So it looks like Justice Blackburne-Rigsby is just joining us as well.
Oh, there she
And
is.
oh, wonderful.
Hi, Judge.
Hello.
Hi, how are you?
Good. Well, if you guys can bear with me for just a moment while I pull up my notes because Cornell had such wonderful things to say. But my computer was here and it timed out. All right, there we go. Thank you, ladies, both for coming. I really appreciate your being here today. It looks like here in person, we've got a magic mirror situation going on. So there is a picture of me and then a picture of you guys on a big screen and receding back into infinity. That's fun. But yes, we're so honored to have you both here today. We're very lucky to be joined by two respected jurists. We have Justice Greenwood from my court, who is my boss, and Chief Justice Blackburne-Rigsby from the DC Court of Appeals, who is our coordinator Laura's boss. And we're so glad that you could both make it today. Chief Judge, I'm used to having justices, but Chief Judge Blackburne-Rigsby has been the Chief Judge for the District of California Court of Appeals since 2017.
District of Columbia on the opposite coast, Washington, D.C.
Yeah,
Yeah.
DC Court of Appeals.
So it's later for you. We thank you for taking time out of your afternoon. All right. She chairs the Joint Committee on Judicial Administration for the District of Columbia, as well as the AI Task Force for the National Conference of Chief Justices and the State Court's AI Rapid Response Team. Before joining the judiciary, Chief Judge Blackburne-Rigsby was an associate at the law firm of Hogan and Lovells, where she started her legal career. Then she joined the District of Columbia Office of the Corporation Counsel, which I see is now the District of Columbia Office of the Attorney General. While she was there, she served as special counsel to the Corporation Counsel. She then served as the Deputy Corporation Counsel in charge of the Family Services Division, where she managed the division's 65 attorneys and support staff responsible for handling child abuse and neglect, child support enforcement, and domestic violence cases. She has also taught trial advocacy at the Harvard Law School and teaches professional responsibility as an adjunct professor at the University of the District of Columbia. And my apologies, ladies, for reading off of a script here. You're both so accomplished. I cannot hold it all in my head. All right, and then Justice Greenwood is the administrative presiding justice for the California 6th District Court of Appeal. That's where I work. Hello, Judge. And she also joined the court in 2017. She has been our presiding justice since 2018. She started public service immediately after her graduation from Hastings College of Law in 1981. She started at the Public Defender's Office, eventually rose to the position of public defender, appointed in 2005. At that time, she directed an office which provided representation in approximately 35,000 cases annually. and supervised a staff of 250. During her tenure as the public defender, she led efforts to reform juvenile justice and reduce youth incarceration. She held that position until being appointed to the Superior Court in 2012, where she served in the civil law and family law divisions. We are so lucky to gain her fierce intelligence and commitment to justice at the 6th District Court of Appeal. Since becoming our PJ, in addition to the small regular day job of being a justice, she has also seen our court through a pandemic. She has secured funding and a location for a permanent courthouse, something that we have been trying to do since the 1980s. She's co-headed the initial exploratory task force on AI for the California Appellate Courts, and now serves on the continuing task force in addition to many other volunteer activities. Both of these ladies have won many professional awards throughout their careers, but I would like to let them talk, so I'm not going to list them. That might take the whole time. They both have spouses who are also judges on a personal note, and they both have an adult child. And I'm pleased to bring them together to talk with us today. I do have some conversation starters, so you scroll down. If either of you would like to jump in at any time, say anything, please just go for it. But just to start with, it feels like we've been talking about AI for a long time, especially in the library world, but really it's only been a very short period. ChatGPT became available to the public in 2022, with legal services following shortly behind, with CoCounsel launching in 2023 and Lexis AI the same year, a little bit later. The legal field is usually notoriously slow to adopt new technology, but it seems like AI has been an exception to that rule, probably because of the massive time savings potential that anybody can see after seeing some demonstrations. However, in the courts, we're taking a little bit more of a measured approach. Could I have the two of you talk just a little bit about what's going on behind the scenes and why we might be seeing that difference in speed of adoption?
Well, I don't mind jumping in. I just wanted to say first, thank you all so much for inviting me to be a part of this wonderful discussion. And it's a pleasure to meet Justice Greenwood. I didn't realize your husband was a judge also, or a justice also. I noticed my husband went to Hastings as well. So although I know the name for Hastings has changed, but you're a fellow alum there. And I just want to say thank you to law librarians first. You all are awesome. Our own Laura Moore is just invaluable. She serves on our DC Court's AI task force, which I stood up recently to help our courts grapple with it, both our trial court and our appellate court. We're a two-tiered system, so we don't have an intermediate appellate court in DC. And I just remember when you say it's just only 2 years, barely, that ChatGPT came out. I remember we were talking about it at a Board of Judges meeting, which is our monthly policy meeting. And that was about the time that I had begun my term as president of the Conference of Chief Justices. And I said, we've got to get a handle on this. It is moving so quickly. And I created what we called the AI Rapid Response Team, which was a national task force looking at the use of AI and helping state courts and state court administrators and state high courts understand AI and how it could be rolled out and used effectively in our court system. But first we had to understand what it was, just basic definitions and principles. And we've got a wonderful resource center online, which I won't spend too much time talking about, with the National Center for State Courts. And so we're proud of a lot of that legwork. But my work there prompted me to stand up a task force for our own courts. And the first thing we had to grapple with was what we need a use policy. We're past the point, in my view, where we could say you can't use it. It's prohibited under every circumstance. And so we're about to finalize our use policy where we try to balance ethical considerations, privacy concerns, because courts are the repositories for so much data, personal and sensitive data for the parties who have cases before us, and to make sure that we weren't inadvertently sharing important data that would be a part of a large language model of some of these AI systems. So it's moving rapidly, but one thing I think we learned, sadly, through the COVID-19 pandemic years is that change is inevitable and that the pace of change is increasing. It's not going to slow down. We haven't reached the point where we're here, we got it. Every time we get to a point where we think we know what's happening with AI, it grows, it changes. So we have to continue to be agile, nimble, innovative, and accustomed to changing. That's something courts and judges have always been known for, but we've shown that we can do it.
Absolutely. Justice
It
Greenwood.
is, thank you, Jocelyn. So I'm just gonna say one thing before I start responding in this conversation with Judge Blackburne-Rigsby, and it's so wonderful to meet you, by the way. My husband's on the federal bench, Ed Davila. He's in the Northern District, so
Oh, wonderful.
colleague of yours. But in terms of the librarians in the group here, what I say is that Jocelyn is the library. Her brain is the library, and I think more and more that has come to be the case about all of you. It's most of the people who come to work for our courts, the idea of using a book is really actually pretty alien to them. And so they're used to all the online services and all that that has to offer. I mean, I started practicing in that sad date of 1981, and I know all about manual shepherds. But you know, a lot of our folks have never touched a shepherd's manual in their lives. So Jocelyn is indispensable. Each of you are indispensable, and we are so grateful for what you offer to the courts because we couldn't do it without you, honestly. So thank you so much for your service, first of all. And of course, you're fascinated by AI because it's an extension of what you do in so many ways. Jocelyn, you were asking about the speed.
Yeah.
We're actually very much on track with Judge Blackburne-Rigsby's timeframe that she's talking about. California is the largest judicial system in the United States. I'm sure a lot of you are aware of this. I mean, we have over 1,000 judges. We have 104 justices in the courts of appeal. There are 58 counties. We have 7 Supreme Court justices. I mean, it is massive. And we have at least 39 million people in the state. Even though they keep saying we're shedding people, I don't believe it, not based on the traffic, I'm just going to say. So, you know, we've got a lot of folks we have to serve. So whatever we're going to do, you know, whatever innovation comes along has to be done with a lot of consideration about how it's going to impact court users, those of us who are tasked with administering justice effectively, and those who actually are the ones who make the decisions. I mean, the judges and justices and so forth in the system. And that's a complex thing. We also are the reactive branch, which is appropriate. You know, that's our role under the Constitution, so that's fine. But, you know, for those of you who like The Devil Wears Prada, which is one of my favorite movies, I mean, you know, by all means, move at a glacial pace. You know how it thrills me. I mean, at a certain point, I know James Mixon, who's the managing attorney for the Second District Court of Appeal, is here. I mean, he and I were like, no, come on, let's go. Because we were getting nervous that the California was starting to, as the largest, you know, judiciary, was, pardon me for putting it this way, not quite getting with the program. But we have a magnificent Chief Justice, the Supreme Court, and she, of course, got on top of it. And really what we're trying to do in the same way that Judge Blackburne-Rigsby was describing, is we're trying to balance all this excitement about this innovation, ways that these things can be helpful to us, to self-represented litigants, and so forth. but also taking into consideration a number of concerns, challenges that we have in the court system that don't exist in private industry in quite the same way. People give us their information. They expect us to keep that information safe. So we do have the issue of confidentiality, she mentioned. We need to be transparent. We need to maintain public confidence in the judiciary. I don't think too many people are thrilled by the idea that they would go to court and a bot would be making a decision about, where their kids are going to go in the divorce. I mean, people bring the most intimate parts of their lives to the state courts, and we have to respect that. And so AI can be a tool, but we have to be transparent about when and how we're using it so that people remain and continue to use the court system in the ways that we want them to. We also need to be concerned about bias, because I know all of you are very acquainted with AI, so I don't need to go into this too much, but pardon me for quite putting it this way, but garbage in, garbage out. I mean, the large, learning models, they've learned a lot of things that aren't accurate. So there's an accuracy issue, but they also can be just skewed in particular ways that can be worrisome. And James here showed us a wonderful picture that he generated. Wish he could do it here in the session because it would be fun. But he showed us this picture. He said, show a group of appellate lawyers. He could have said, show a group of librarians at court, librarians or librarians. And up popped this, sketch that basically was a lot of white males in a strangely Hogswort looking library. It was really interesting. You would have liked it, but so then he said, we'll do it in anime. So that made it a little more ethnically diverse, but didn't do a whole lot more than that. And there were almost no women. I mean, so it does, it is as good as the information that it's been learning off of, at least at this point. And I will also say this, I don't think we have vendors for any of the major companies here, so I feel free to say this. For our purposes, yes, useful in some ways, maybe now, definitely will be useful in the future, but not quite ready for prime time on a lot of things that we do. And we have to be right, or as right as we can make it. So that explains some of the delay, I think. Having said that, California is adopting a model use policy, a rule of court, which is now circulating for public comment, and a standard of judicial administration, which is designed to govern what judges do, because there are ethical concerns about how we can use AI. I don't think I should be handing off my appellate decisions and saying, here, run with this tiger, and then not reviewing them. So.
Absolutely. Yeah, I remember you did a presentation, Justice Greenwood, to the JCC, and mentioned that since AI is inherently backward looking, it's based on past patterns of behavior and decisions. And if you look at the history of the law in this country, when you say garbage in, garbage out, I mean, there are a lot of old cases that are not upholding our modern values. But if you look at, for example, the Brown versus Board of Education, AI would never come up with the decision in that case, because looking backward, it would not have the capacity to do so. And so you really can't replace the judgment of a judge or a justice, or really just any human being, with a mathematical model that is based on pattern recognition. So I thought that was very insightful.
It was, and not a thought original to me, by the way. I'll give it to James for that as well.
Yeah,
but it is true. It is based on, it's a predictive model.
yeah,
Yeah.
yeah. Okay. Access to justice is very important to our judicial system and to law librarians in general. What opportunities do you think AI will offer to self-represented litigants and to increasing access to justice in the courts? I think that there's a lot of opportunity there, but the road to get there, maybe not so clear.
Yeah, I think this is an opportunity, an area that is ripe with so many different opportunities. You talked about chatbots. Those are very helpful, but the chatbots that I know have are sort of past generation chatbots. We have the technology is available now to make them much more lifelike, much more helpful, basically, to the questions that self-represented litigants might have. AI is a great tool to help summarize complex documents or summarize a court order in plain English. The use or possible use for AI in the courtroom to transcribe proceedings could be more cost effective. And, there is a shortage, at least in our court system, of court reporters, actual court reporters to sit in the courtroom. And where AI could get faster transcriptions, which would then perhaps need to be reviewed or checked, but maybe not. It could be an initial step so that litigants could have something in their hands without having to pay expensive transcription services. There are, one area where we have some potential concern is the whole area of unauthorized practice of law. And, there's a lot of information out there on how to write your own will, how to file your own pleading, and there are some questions that we're looking at in an AI and ethics working group that I'm a part of about when you start to run into questions of unauthorized practice. But I think before you get to that stage, there's so much that can be done to help litigants, self-represented litigants. And I think what people don't realize, we're in Washington, D.C. We have, I think it's the third largest unified bar, despite our small geographic size. Not everybody practices in D.C. that's licensed in D.C., but in our bar, where you have so many lawyers every day in our local courts, you have staggering statistics. 97% of folks in landlord-tenant cases facing loss of their home are unrepresented. And it's close to 90% in civil domestic violence cases where people are seeking a protection order, custody cases. And the impact there could be great if people had a reliable AI tool or resource that they could use in conjunction with their proceedings to help represent themselves. So, making lawyers, freeing up time of lawyers so that they have more time available to do pro bono work is possibly an area where AI can help. If AI, which has been proven effective in large document searches where you're looking through boxes and boxes or the equivalent of boxes and boxes documents for search terms, AI in some instances has been proven to be more reliable and effective and faster. And so perhaps that time saved there, attorneys who are grinding over not a real exciting assignment of document review could have time freed up to do a pro bono case. So there are lots of ways I see that we could leverage AI for self-represented litigants. We're actually starting. I've been on the bench now for 28 years and started in our trial court the first 11 years. And so I was used to seeing self-represented litigants, but the number has increased exponentially. Mm-hmm. And then we're starting to see them in the appellate cases increasingly. And that is really difficult when you're having parties try to navigate these legal appeals and cases that are near and dear to their lives without counsel. So there's a tremendous opportunity for AI in the use of self-represented litigants, but it has to be, again, we talk about guardrails and safeguards so that they don't end up getting hurt or misserved when they try to use a tool that they think is going to be the answer and help them with their cases. So
I think an important thing to realize about a lot of court proceedings is that they start with filling out forms. And most judges make decisions with self-represented litigants based on the information in those forms. It's not that they don't hear what they have to say, but the first step is what was put in the domestic violence restraining order request, what was put in the, I'm a, widow and I have a small rental property and I can't get some fellow out who shouldn't be there anymore, who hasn't paid his rent for 6 months. How do I get him out? And it can stop with the form. If the form isn't done correctly, it's like you do not pass go. And I think courts try to be as forgiving as we can about that, but there are a lot of ways in which people are very disadvantaged when they don't know how to put that information in. Or even if they do get the information in, the better and more complete the information is, the more effective the judicial decision is going to be. So I think your point, Judge, is just so well taken, because having AI assistants to be able to work on those things could really benefit people. And it's a concern in that we're seeing just in the last year, the number of self-represented litigants who are filing appeals is really high. And one of the things that's of concern to us is a bedrock proposition in appellate law is that the order we review is presumed to be correct unless the appellant demonstrates that there's an error. And many self-represented litigants are either not sophisticated enough to understand how to demonstrate the error, which AI might be able to help them with, quite frankly, not by practicing law, but just by saying, what is it you're concerned about, and then helping them write it a bit. But also, they don't have the information to attach to their appeal to make it reviewable. So, that bedrock principle was premised on the idea that you'd have, equal sides. And so if somebody left something out, too bad for you, you should know better. But when it's lopsided, and you've got, this doesn't happen too often, but often enough, big major law firm and then self-represented person on appeal, and they don't know what to do, and then they can't show that what happened seemed unfair to them or why. I'll tell you, I hate writing those opinions that say, unfortunately, we don't have a record in order to provide relief to appellant. We're required by law to presume that the order is correct. It actually breaks my heart to do that. Now, maybe there wasn't an error. In fact, most of the time, probably there isn't an error. I mean, what we reverse in maybe 10% of the cases maybe get reversed, but it's enough that it shouldn't just be if you're represented by an attorney, there's an error demonstrated. So we want to make sure that what we do is helpful and accurate, and I think AI could do that. You asked what one of the constraints was in that, Jocelyn. I'll tell you what one of them is going to be is money. Budget's a big thing. AI costs money. These companies they want to be paid, and I'm quite certain that they're going to charge the court, figuring government has deep pockets. I'm quite certain they'll want to charge the court a lot of money for some of these things. And that depends on budget allocations from legislatures and so forth. So we hope that the voices will be strong enough in the legislature to persuade the folks who control finance to help us help people more effectively, because it will be, I think that's going to be an issue.
Yeah, I think Justice Greenwood, you touched on a couple of points that I think are really key when you talk about the money. And people, on the one hand, AI is so accessible by many folks, but it's not equal access. A law firm that can afford all of the fanciest, most modern AI tools and keep updating them, and in addition to ChatGPT 5 or 6 or 5.0, I forget where we are now, they have Claude and they have CoCounsel and they have Lexis AI. A self-represented litigant doesn't have equal technology access. They may have a cell phone, but it doesn't have the plan that has the data sufficient to operate some of these platforms. And so we have to be careful when we're talking about AI and its great potential for increasing access to justice, to recognize there's also a digital divide, that not everybody has the means to have the best technology to do all these things. And I think that plays a little bit into the public trust and confidence, which Justice Greenwood mentioned. And I wanted to share when I was president last year of the Conference of Chief Justices, which are the chiefs of the highest courts of all 50 states, the District of Columbia, and the U.S. territories. Each year, the National Center for State Courts, which serves as the secretariat for the Conference of Chief Justices, does a survey. We've been doing this survey for about 12 years, looking at the state of state courts and how people view our courts. And some questions have been constant. And one of the questions that we've constantly asked has been about public trust and confidence in the courts. And for the first time, and typically the courts have the highest level of public trust and confidence over the other two branches of government. And state courts had a higher level of public trust and confidence over federal courts. And I think that's because 95% or more of all people who ever go into any court to have any kind of case adjudicated go into our state courts. But we also add for the first time, I think 3 years ago, we saw public trust in courts and in state courts dip. And we being the Conference of Chief Justices, wanted to look at why that is. And so we asked some extra questions in the last couple of years. And one of the new questions we asked was, if you knew that courts were using AI for some things, would that make you feel good about state courts, and would that increase the level of public trust and confidence? And the answer was yes, but for some things. Yes, if it would help us fill out forms. Yes, if it could help us transcribe proceedings. But it was a strong no if it meant that judges would AI would be substituted for actual human beings. And so that tells me that the public expects courts to be embracing certain kinds of AI technology, and they expect judges to understand it and to know about it. And the more we educate ourselves, judges and court administrators and law librarians, I think that helps to increase public trust and confidence in state courts. And the other piece of that was knowing when one of the questions on the survey this year was something to the effect of, did you know that all state courts judges are subject to judicial codes of ethics? And that was not something I think people widely knew. And knowing that helped give an extra sense of public trust and confidence. So I think my takeaway on access to justice is people in the community who use our courts want us to embrace AI and allow them to use it for some things. But they also want to make sure that we're providing appropriate oversight and safety and guardrails.
Wonderful. Yeah, and since this is a librarians conference, I'll have to mention that we've got a number of California County law librarians here joining us today, and they're an invaluable step when we get past the form, but there are additional pieces of information that need to come before the court. And sometimes people don't know how to bridge that gap between the form and getting the information before a judge. And of course, the courts have many self-help centers, which are wonderful, but when those don't quite do the trick, often our California county law libraries are an invaluable assist to those self-represented litigants. And so I just want to thank all of those people who are here today.
Librarians are a powerful tool there because, often people in the community know they have a problem, but they don't always know that there's a legal fix to the problem. And they go into libraries, they utilize libraries, and they ask you questions. And knowing that you all are armed with information about how to direct them to legal resources is so important to access to justice and to help bridge that gap. So to the law librarians, we need and value you, but to the public librarians, the county librarians, your role is invaluable as well.
Yeah. Okay. Yes. Well, Chief Judge Blackburne-Rigsby, I've got a question for you. Your court recently released a case that discusses AI, which is Ross versus United States, one of the early forerunner cases to do so. I believe it was early forerunner as in it was released within the last month, I think. So very, very recent. Would you talk a little bit about the process behind that case and the different judicial points of view that you can see in it?
Sure. Our court, as I mentioned, is sort of a hybrid in the sense that we don't have an intermediate appellate court. So we are the high court or the court of last resort, but we also sit as an intermediate appellate court also. So we'll sit, we're a 9-judge court when we're fully staffed. We currently have 2 vacancies. We sit typically in 3-judge panels, except when we sit en banc as the full en banc court. So this was a 3-judge panel of the court, and I would say our 3 newest judges, which is interesting in the sense that they embrace the technology, and the appeal. The topic of the appeal was sort of a bread and butter. It was a criminal case where a woman was convicted for animal cruelty under the criminal animal cruelty statute for leaving her dog in a parked car on a hot summer day. And the windows were only slightly cracked and the temperature got up to 98 degrees. And the government, in prosecuting the case, wanted to show that it was, quote unquote, common knowledge that the appellant's actions would cause harm to the dog. And the court, in its opinion, the majority opinion, reversed the conviction, ruling that the government couldn't just use common knowledge to fill the crucial gaps in the government proving their case beyond a reasonable doubt. And so one of our colleagues, Judge Deal, dissented, and his basis for dissenting was, of course, this was common knowledge. If you leave your dog in a hot car, it's not good for the dog. And so in his dissenting opinion, he discussed his efforts to query ChatGPT and ask them the question, if I leave, is it harmful to leave a dog in the car with 98-degree temperatures? And the ChatGPT said, of course, it's common knowledge that if you do this, it's harmful. Well, the judge who authored the majority opinion disagreed. And so he did a ChatGPT query about a hypothetical case like this and whether it was common knowledge. And ChatGPT gave him a different answer, supporting the majority view. And then the third colleague on the case, Judge Howard, who joined the majority, reversing the conviction, wrote a concurrence. And it turns out Judge Howard is the chair of our courts-wide AI task force. And he wrote a sort of a thoughtful query about some of the concerns of using AI in the judicial context, where you could potentially preview the thought processes of the panel, you could disclose private information, but that those weren't present here because both judges who used it in their separate opinions were transparent. They included their queries to ChatGPT and how they got the responses they did. And so it was it's interesting the use of the Chat GPT was not the underlying issue, but it has generated quite a bit of buzz, and the thoughtful concurrence by Judge Howard, just looking at the importance of a use policy for courts, some of the ethical considerations, and some of the privacy and safety concerns was informative. So commend it for your reading, and encourage you not to leave your dogs in hot cars with the windows cracked.
I agree on both points, absolutely. Okay. Well, I believe we talked a little bit earlier about the work of the courts and the role of AI in the work of the courts, our hopes for the future in an ideal world where self-represented litigants are able to come to the courts with their concerns and issues and get help. And hopefully that would increase the number of people who are able to effectively access the court. But if that all happens, we also talked a little bit about appropriations for the courts and the difficulty of getting funding. How do you think that those issues are going to play out? If there is a huge number of new people coming to the courts to resolve their problems, that's a wonderful thing, but the courts have a limited set of resources. Could you talk about that a little bit?
I don't know how I don't know how easy it is to predict.
Yeah.
That there would be a surge, a tsunami of new cases based on the use of Gen AI for self-represented litigants. I'm not so certain that's going to be the issue. What I do think is the more immediate issue for the courts is that there are more and more presentations of AI in ways that what we've talked about so far has been, self-represented folks being able to access Gen AI in ways that could help them provide better information to the courts with hopefully then outcomes that are more satisfying, to everyone, and maybe more efficient too. If their pleadings are better, then you don't have to spend an hour figuring out what the pleading is. But I think the other thing is that we're starting to see evidentiary issues. There are a lot of legal issues about judicial notice. There are questions about judges' use, as Judge Blackburne-Rigsby was just discussing with her case, judges' use of AI. And each time you confront something new like this, it takes a lot of time and resources, on the part of the judiciary to think it through carefully. And then perhaps respond. I mentioned this, and this is a different context, but California is in the middle of a lot of different legislative change around criminal justice, and much of that is hitting the trial courts and the courts of appeal now. Now that's feeling like a tsunami to us, I will tell you. So if you start getting presentations of things that require you to have to go back and really rethink the basic underlying principles. So just to give an example, I sat in family court. A lot of people would come in and they'd say, Judge, look, I don't know if you can see this. Oh, you can see my little screensaver with my dog, Rosie. Anyway, Judge, here, look at my phone, they would say. There we go. I'm sorry. It was not pixelated. So, look at my phone. This is what he did. Well, now with deepfakes, I used to actually just get off the bench and walk down, and I myself would walk through an authentication with people because that wasn't something that they understood how to do. But I needed to make certain as a fact finder that I trusted what I was looking at. Having to deal now with this whole other layer of, can I trust this or not trust this? I'm not certain. What's the standard going to be? And so forth. All of these are causing the use of a lot of, I would say, judicial resources, the presentation of these issues. That, I think, is the first wave. Once people start to maybe use Gen AI a little more in terms of their presentation of their cases, maybe we would see an increase in users. But I don't know, Jocelyn, if that's true. I don't know, Judge, what do you think? Are we going to get a bunch of new users based on this?
I don't know about the new users. I sort of had a question mark next to the question. as I was thinking it through. But I definitely agree with you, Justice Greenwood, that evidentiary issues are going to be huge. And you know, how do you authenticate a deep fake? Some of these are very good. These are very good. Someone played for me in one of our AI rapid response task force meetings, me doing a presentation on the findings of the task force. The problem was it wasn't me. They took a 20 seconds or less soundbite of me from something else and were able to make my voice say all kinds of things in different languages too. So it is, so, you know, domestic relations cases or domestic violence cases where they're trying to say, here's a threatening phone call. Is it real? How do trial judges as gatekeepers decide these issues? And then on appeal, what do we do? As appellate judges, do we look at the deep fakes and decide what we think is a fake and what isn't? Well, there are experts that do that. And so I think those kinds of spin-off issues, it's hard for me to envision different kinds of additional types of self-represented litigant cases. Because I think self-represented litigant cases, most self-represented litigants don't want to come back to court over and over and over. Again, you do have some frequent filers, but for the most part, people want a resolution and they want to move on with their lives.
Absolutely. All right. Well, both of you have been on AI task forces for your courts. What are some of the practical considerations that came up while discussing AI in that venue? Is there anything that really stood out to you as being especially interesting or thorny?
Just that stuff changed so quickly.
Yeah.
Initially, right after ChatGPT came out, when we first did the National Center for State Courts and Conference of Chief Justices AI task force, we would meet every 2 weeks. And literally, when we come back in 2 weeks, something would be different. And that was just trying to get the fundamental language down. I think now more people have a better understanding, but the technology is expanding, growing at such a rapid pace. And then, you know, there's areas we haven't yet delved too deeply into, like what are the new causes of action that we might start to see with tort liability, for example. I was at a seminar with AI, autonomous vehicles. I think it was things that we've not seen, and not that there'll be new law, but I think the question is what current principles of law will we use, and where might we need to develop some new principles of law? So I think the pace of change is the biggest challenge and also the most exciting thing that I've confronted with these task forces.
I would agree with that. I also think that, and I think also, Judge, that the demographic of judges on the bench, there are plenty of young judges, but young in the judiciary usually means over 40. And, you know, in the world of technology, look, I'm very interested in technology. Judge, you're super interested in technology, but there are a host of people out there who are extraordinarily great judges who really view the computer screen as their enemy. And, they're the same ones who struggle with their remote and whose kids grab their phones out of their hands and say, Mom, let me do it, which, by the way, that's me. So there's the very practical fact that there isn't necessarily ease on the part of judicial officers, I think, in the use of technology. And I think there are going to have to be requirements, whether they're stated or not. But I think one of the ethical requirements of being a judge now is the willingness and flexibility, not just to maintain currency, understanding of the current law, but also understanding of the current technology to be able to access and utilize the law effectively. And I think we saw that a little in the pandemic. Jocelyn, at our court, we had some, absolutely lovely colleagues who they were ready to retire for a variety of different reasons. But one reason they stated to me was we went electronic at that point. and everything started, moving electronically and so forth. And they said, I've worked a particular way now for 35 years and I don't want to do this. I love the law, but I'm not loving this piece.
Yeah.
So, and I respect the fact that they recognize that about themselves. So I think that's a very practical consideration is, if you'll pardon me for putting it this way, how do we get everybody up to speed? And that also includes the support staff in courts because they're not necessarily receptive to changing the way that they do things. There's the money issue is also a very big one. And then the other, I think, really practical consideration for courts is for our use, if we're going to, I hope you're not hearing my dog. I'm so sorry.
You're fine.
Somebody's here. For courts purposes, we have to have closed systems. If we're going to use AI, so let's say I wanted to use AI to help, review a case, look at a record, summarize or whatever. I can't throw that out into OpenAI. That's not possible for me to do that. It would affect the integrity of the process. And how can we work with vendors, candidly, providers, to create systems that satisfy the judicial standard of confidentiality and security. And that's going to require a level of technical expertise that fortunately we have people who can help us with, not me, but I think that's going to be a big one, frankly.
Yeah.
So,
That's an important one. And law firms, large firms have been able to develop proprietary closed systems for their law firm work, but they often have more resources financially to do that. Courts, don't. So that's a challenge, and I agree with everything Justice Greenwood said about the integrity of the judicial deliberations. You can't just plop that into a large language model, and because then it becomes part of the universe, and you don't have safeguards around it. So,
Absolutely. Well, I think we are now 5 minutes past our time. Thank you so much for giving us your time today, ladies. I appreciate it very much. Chief Justice Blackburne-Rigsby, Justice Greenwood. I hope you have a great afternoon. Thank you for your very insightful comments. I think that it was very helpful to everybody to see the court's point of view on these new and emerging issues.
thanks
it
for
was great to see you.
Thank you.
been a pleasure. Thanks, Laura, for inviting me. It's a
Yes,
pleasure.
and Jocelyn and all of you. Thank you so much. And keep being those big brains, please. We need
Yes.
them. We need them.
Pleasure to meet you, Justice Greenwood. Take care.
You too.
Bye.
Still recording, Amy? You're still recording, it's still on.
I think we have a little break now, and I will see you after
wanted
we get
to-
some coffee. Oh, sorry, go ahead.
Note about
Sorry, Laura.
the opinion that's gone viral for us. I'm also our opinions clerk, and so I check all the opinions, and they were not expecting this opinion, why they went viral. So they've been a little, I think, disappointed, if I would tell you that was why they went viral for that particular opinion. So anyway, but just a little side note on
They were, yeah.
She's when I was putting their bios together, I was like, oh wow, these people really need to be. I got to work together when I was at San Francisco Law Library.
Oh, yeah.
Learned a ton. I was like, hey.
No, we're so.
Yeah, we'll have to see it.